Good evening, everyone. I'm Shirin from Maxwell Chambers. Thank you for joining us in our second session of Maxwell Conversations. Today, our guest speakers will speak on the topic, Will Asia Change International Arbitration? Before we begin, please take note of these points. So for our participants claiming CPD points, please stay throughout the entire webinar. Second, we will have a Q&A segment later, so please type in your questions via the Q&A function at the bottom of your screen, and our speakers and panelists will be addressing selected questions. Third, if you have any technical difficulties or inquiries, please drop us an email at marketing@maxwellchambers.com. We will also like to thank the following organizations for their support. I would now like to hand over the e-stage to our host and moderator, Lawrence Teh, Senior Partner and Co-Head of the International Arbitration Practice at Dentons, Rodyk. Over to you, Lawrence.
Welcome everyone to Maxwell Conversations, which features conversations with high-profile international arbitration lawyers on topics in international arbitration, and challenges assumptions with a deeper examination of the issues. In this second conversation, my guest is Professor Julian Lew QC, full-time arbitrator and head of the School of International Arbitration at Queen Mary, University of London, with whom I will speak about whether Asia will change international arbitration. We will be joined later by representatives of the three most preferred arbitral institutions in the world: Sanjeev Kapoor of the ICC, Nils Eliasson of the HKIAC, and Kevin Nash of SIAC, as we consider the institutional perspective. Now, if I can invite Julian to come on to this event. Julian, welcome. You were trained as a barrister and then became a solicitor and went on to be a partner handling international arbitration in 3 London law firms from 1986 to 2005, by which time you were appointed Queen's Counsel. Concurrent with your time as a partner, you also had your position at QMUL. Since 2005, you've returned to the bar and you've since been an independent arbitrator. Julian, could you tell us what has occupied your time recently?
First of all, thank you very much. It's a pleasure to be here. I'm sorry I'm not there in person, but that's one of the problems we live with in today's world. Maybe it'll change in the not too distant future. Who knows? Yeah, I left the law firm almost 17 years ago. And since then, my practice is almost exclusively as an arbitrator. I sit in mainly international commercial cases and investment cases. From time to time, there'll be something a little bit different, all in the same area of being primarily based on international law, public and private.
One of the questions I had for you in this conversation, Julian, is how you've perceived Asia's historical participation in international arbitration. And I do refer to international arbitration as opposed to, say, Asian domestic arbitration, other forms of dispute resolution. What have you, over the years, seen to be Asia's participation?
Well, let's go back a step. When we talk about Asia, Asia is it's bigger than Europe. And you'll recall that or you may recall, some 8 years ago, I gave a address in Hong Kong when I talked about the way I saw arbitration moving from other places to Asia, not necessarily excluding those other places, but actually building in. And I gave several for that. One, and let's not focus primarily on Hong Kong and on Singapore, but across the region. First of all, there was the independence of countries that had been under colonial rule. Secondly, there was a fast development of economic strength in many of these countries. Of course, developing economically takes a lot of time and governments don't always get it right, but the governments in Asia actually looked very carefully to try and get their economies going, and that was happening. A third factor was globalization. And then there's a little bit of parochialism, which is this. We all loved traveling before COVID. We all liked flying in aeroplanes to one side of the world or the other. And we took with it the problems of travel, the inconvenience of travel, and jet lag. In the old days, parties in Europe could say, you come to us for an arbitration if we need one. That's not the case anymore, because many of the Asian participants in international trade, they're governments, they're government entities, there are some very, very large commercial entities and some smaller but successful commercial entities, and they have enough clout to say, no, let's talk about a level playing field. Maybe it's the time for help to come. And the proof of that, and I'm sure you're going to take me to that later, is the fact of the amount of increase in arbitration in recent years that has come not only to Singapore, to Hong Kong, but to all the other regions in Asia, including arbitrations under the ICC.
You say quite rightly, Julian, that Asia is a big place. It's a big concept. And indeed, in the old days, Asia was synonymous with what was called the East, the Near East, the Middle East, and the Far East. When we talk historically about Asia, would you put it all together? I mean, are you referring to, for example, just the Far East, or do you speak in general of everything that was east of Istanbul, if I can be cheeky?
Well, I guess there's always a question, where does Asia begin? I'm still thinking of my childhood education when we were talked about the continents of Asia and Europe and Australasia and Africa. So from that point of view, Asia is a very big unit. But look at when sometimes it's broken down into other areas, such as talking about the East Asia, South Asia, and Central Asia, and the Pacific. So there's a whole part of Asia. And can I add one other factor which I think one has to take into account? There are numerous political, cultural, legal systems in this bigger Asia. So we can't really start attributing any particular thing to such a vast area. But what we can say is that we are seeing that area as a whole, which has become far more powerful economically. The political movements have changed, with countries becoming independent in some ways, and other arrangements being made between countries, international agreements being reached. And that's a factor that has actually happened.
Everyone has heard of, or perhaps even experienced, the rise of Asian economies since the latter part of the 20th century. Would you say that together with the transactions that are generated, and of course the byproduct of the disputes coming out from these transactions, has given rise to greater familiarity, trust, and participation by Asian businesses in international arbitration?
That's no doubt correct. There are other factors. These major corporations, all kinds, they may be manufacturing, they may be financial, they may be consultancies. Leading players there are from different parts of Asia. Some of them are multinationals. They are meeting with people from other corners of the world, from all over. They're developing relations, sometimes good ones, sometimes they're having difficulties, But even a difficult relationship gives parties the opportunity to try and understand the way somebody else thinks, the way somebody else works, the way somebody else approaches life. And that's quite an important factor. And then when a deal is done, there's already, the parties have worked to try and get an understanding of one another. And then when something goes wrong, they end up in a dispute and they need perhaps to go to arbitration. They already have a feeling of one another. They wouldn't have got to arbitration if they were able to resolve matters. But the basic trust that might have been there when they did the deal will be undermined in respect of the contract, but not necessarily with the overall personality of the company and the regime or area from which they come.
If I used my own personal experience, if I brought that into our conversation and said to you that one need only look back to the last 15, 20, perhaps 25 years to see and find that Asian parties were skeptical of international arbitration and its processes, that they would sooner run home to their national courts and get injunctions to try and derail the arbitral process. Would that ring familiar to you?
Yes, and I can give the other side of the coin as well. There is a familiarity with that, but there is something else that comes in, and that is one has to look behind there, where there were countries or parties from countries where there was the stigma, not a stigma, but the feeling of working with a former colonial or a former country that had some influence, excessive political or economic influence over the country from which the other party comes. A little bit of that may still remain because the multinational is much bigger than the big company. And they've much more international experience. I think that's one factor. The second factor is we are, all of us, more comfortable in our own homes than we are somewhere else. So it's not surprising that a business is much more comfortable in their own national courts, with their own local lawyers in dealing with the matter. And that's been the success of arbitration, is persuading big companies that, first of all, there are lawyers who are capable of dealing with these kind of cases, even if they're not of the same nationality. And that secondly, it is possible, this is a separate issue, but it is possible and should occur in most arbitrations to develop a hybrid procedure which takes into account the expectations of the two parties. They're from very different systems. They will have very different expectations of how the procedure will follow. And if you want to, we can explore some of that.
Yes, we'll come back to that in a minute, but I'd like to take you now to the QMUL International Arbitration Survey of 2021. Much has been said about it. It's been spoken of in many different ways since it was published. I thought that to better orientate the audience, perhaps you could tell us in broad terms about the conclusions of the survey and more pertinently, what the survey says and what it does not say.
Well, it says what it says. I'll work on that. Let me just give you a little bit of background. Do you remember when we were all young lawyers, and I guess I'm probably one of the older ones here, when we talked about arbitration? Arbitration was inexpensive, and it was quick, and it was confidential. And you could choose your arbitrators, and you could choose the law, and you could choose who you want to have it. True? Yes and no. But certainly the first three, that's what we were always told. One of the things we started doing, and we put together with some major corporations with their support and their advice, is to determine some of these things we've taken for granted and some of the other issues which one wants to know about, to have a look at an empirical study. Now, it's one thing by telling you that arbitration is inexpensive. How do I know that? If I can tell you I've had 10 cases and I've had 10 cases in the court and they were much less expensive, I've got some basis. So all of the surveys that we've done at Queen Mary have been based on a series of questions in which we have sought contributions or responses from people around the international arbitration world. We've been to lawyers, we've been to arbitrators, we've been to corporations, we've been to governments. Of course, not everybody wants to put their name to a questionnaire. I'm sure you get those as well from time to time. Even when you go to stay in a hotel or you go to a restaurant, they send you a survey afterwards so that they can tell you whether it was a good experience or not such a good experience. Over the years, this survey that the Queen Mary has been doing we've done 12 of them so far, the latest one was the 12th, have been had an increasing number of respondents, and also we've had many of those are willing not only to fill in the questionnaire, but also to talk to the person who is the person or persons who are doing the survey. And that's been very, very helpful, and you get an opportunity to really draw some conclusions. That's been the basis of it. So one of the questions is, where do people like to go to arbitration? Now, so what do we get? We got an answer that which were the most popular places to go for arbitration. And you've seen, I think, the survey, which shows that the most preferred method of arbitration, and that's very interesting. A lot of those people who answered, most preferred, 90% of respondents said, for international transactions, their preferred place of arbitration, of dispute resolution, was arbitration. Some of them said, yes, they'd like to have some ADR involved, maybe a mechanism to try and settle matters. The key issue was going to an international tribunal. And that's a very fundamental issue. The second thing is, where do you want to go to arbitration? Well, we know that there are a large number of very good institutions around the world, in Asia and elsewhere, and we also know that there are increasing number being created. We know some are specialists, we know some have a lot of experience. So you and I and others may have a particular comfort with some of these institutions that we work with. By contrast, the corporate who has to make a decision in respect of a corporate transaction or an international transaction of some side, they will have to choose a place with which they are comfortable. And so the survey from all those who answered said, well, what's the most boring, where do you prefer going to arbitration? What are your favorites? And the 5 that came up, as you've seen from the report, was London, Singapore, Hong Kong, Paris, and Geneva.
We seem to have lost Julian's connection to Julian momentarily.
Hearing me?
Could you repeat the last minute or so? We lost you temporarily, Julian.
Sorry, I don't know why. Let's go again. What I was saying is that from the respondents who answered the survey, they told us which were the 5 most popular or their preferred seat of arbitration. And as you know, London, Singapore, Hong Kong, Paris, and Geneva came up in that order. Why? We don't really know. And we don't know exactly where the contributors came from. But that came out, because we know that there are other very good seats which are very effective as well. And then the question is, which institution? Now, we also know, let's not forget, ad hoc arbitration will be extremely successful, and is very popular as well. And we ask the same questions. If you're going for an institution, what are your preferences? And here we got a preference of the ICC, which came first, and then SIAC, Hong Kong, LCIA, and CTAC. Now, CTAC, of course, is an enormous institution, as is the ICC. In international terms, and we may hear a little more from Sanjeev later, but the ICC has been going, I think they have their 100th year of the court in 2 years' time. It's a major, and of course, they've known over the years, they've been in the forefront of changes. Other institutions have got involved at a later stage. But, you know, people look at these institutions, and this comes out, it's not really surprising that the Asian parties say, well, we can go to an ICC arbitration and we can have it somewhere in Asia, still under the benefit of their rules. We can also go to SIAC, HKIAC, and the other institutions that exist. But this is where we got on the five that were the most popular. If there comes a discussion, we can try and discuss that a bit later. Let me make one other comment with respect to the survey, and that's diversity. And diversity is a big issue in this day and age, and widely discussed, and in some ways is politically charged. And so we asked, the survey asked contributors or respondents, where do we stand on diversity? Are we seeing sufficient diversity in the context of international arbitration? Well, what is diversity? Is it gender diversity? Is it cultural diversity? Is it geographic diversity? Is it ethnic diversity? And none of those are clear, well, not all clear cut. And half of the respondents on this survey said that they consider that progress has been made. So that's very positive. And they certainly in the context of gender diversity. Now, it's hard to measure progress, and certainly in the many years I've been involved in arbitration, there are now, on the gender side, many women who are involved on both as practitioners, running senior positions, the major arbitration institutions, and of course you've got the president of the ICC and the LCIA, and one other that are ladies who are running those institutions at the present time. And of course, there's one in Singapore where Lucy Reed is now, I'm not sure if she's taken over yet or is about to take over as president. So at that level, there's no question about, in my view, no question on diversity. The second area is the question of arbitrators. I've now sat on numerous tribunals with one and with two women. I've been in the chair with lady arbitrators, and I've been chaired by lady arbitrators. So I think that is breaking through as well. The third area is the legal teams, and there we've all seen, as the legal teams have developed, more and more women within the legal teams, and in some cases, leading the legal teams. So I think there's some progress. Exactly how well that is much more difficult to monitor. Now, there's one other thing I should mention, because I think it's quite interesting, which is whose responsibility is diversity in the arbitration world? Is it the responsibility of the institutions? Is it the responsibility of the tribunals? Is it the responsibility of the legal firms? Well, apparently, the survey came out that 59% of the respondents considered the role of the appointing authority in the arbitral institutions to promote diversity. And that can only be in the context of when they come to appoint arbitrators, to ensure that if they're picking up names to the parties, there should be a fair representation of suitable, qualified, experienced women arbitrators. And I think from figures that I've seen from other institutions, that is happening, maybe not even slowly, it's happening on a regular basis. As for the position of counsel, that's up to law firms, because law firms, particularly not the independent bar, but law firms build their law firm and they always look for the best people they can hire, and you know that from your firm. Of course, if there are really able people, they will hire those regardless of their gender or their backgrounds. And we see that nowadays when in arbitrations, you see people coming in to arbitration hearings from all different places. So that's happening. And I just say one final thing on diversity, which is this, that on the last or the first Maxwell Chambers conversation, there was you, the three ladies. And today it's you with 4 men. So, and hopefully it's been put together carefully, both of these sessions, and that's the way it's broken out. But as long as one is making sure that everybody has a fair opportunity and that there are other ideas that come through, that's the important factor.
Thank you, Julian, for observing our attempts at diversity in Maxwell Conversations. You started off your answer by saying that the results of the QMUL survey say what they say, and that, I think, underscores the basic fact that the survey reports empirical data. Isn't it also true that empirical data itself is dependent on the profile of the respondent to the survey, and perhaps there might be limitations on the content's ability to suggest signs for the future?
Per se, looking just at the survey, yes, I think you're right. Absolutely. But one has to look at it something, because first of all, we don't know that all the people who answered the survey, all the respondents, we don't know whether they had an axe to grind on something or other, whether this was something that they felt very strongly about, whether they were coming from one background or other. We don't know that. But the question is, when you look at something like this, does it fit in with what else we see, whether we're institutional or whether we are individuals, what we see going on in society? When you talk about lawyers in a law firm, you will know in your own firm, what you run, you will know how things have developed. You go back 3 years, 5 years, or 10 years. And then I can tell you that from the university, how our student numbers, actually not only in gender terms, but also in geographic terms, has changed over the years and developed. So if these things are completely out of sync, then obviously something, the empirical study, one needs to look at it more carefully.
Thank you, Julian. We are now joined by our other guests. Sanjeev Kapoor is a Vice President of the ICC International Court of Arbitration and also a partner practicing international arbitration in Kaitan and Company. Nils Eliasson is Vice Chair of HKIAC and Chairperson of its Proceedings Committee. He is also a partner in Sherman and Sterling's international arbitration practice. Kevin Nash is Deputy Registrar and Center Director of SIAC and a member of the Singapore delegation to UNCITRAL Working Groups 2 and 3 on dispute settlement and investment treaty arbitration, respectively. Welcome all. Sanjeev, I'd like to start the panel discussion with you and observe that the ICC has perennially been among the top, if not the top, arbitral institution in international arbitration. What do ICC figures say about usage by Asian-based businesses of international arbitration? And do you see these figures growing relative to, say, Latin America, the Middle East, North Africa, and Sub-Saharan Africa?
Thank you. Thank you, Lawrence. Thank you. And I wish a very good morning, good afternoon, or good evening to all of you, depending on which part of the world you are attending this conversation. So, in answer to your question, Lawrence, I can share the latest figures with you, and I think figures will speak for themselves. 2020, in fact, has been a remarkable year for ICC, and it has marked new records for the ICC. The ICC International Court of Arbitration registered 929 filings, leading to the highest number of cases being administered under the ICC arbitration rules. If you look at the latest statistics of ICC from 2020, the following stand out in particular to Asia. So if we look at the geographical origin of parties, filing came from a total of 145 countries and territories worldwide. And of these filings, approximately 25% of the parties came from Asia and Pacific. Within South and East Asia, the most represented nationalities were Chinese, which included Hong Kong and Macau, 80 parties, and 79 from India and 48 from South Korea. The number of parties from West Asia, that is Middle East, increased by 17% to 296 as compared to 252 in 2019. And in fact, Central Asia also accounted for a small number of 17 parties. So if you look at the numbers, with 25% of the parties coming from Asia, ICC places a great importance on Asia. In fact, it has got 2 case management offices in region, with 1 in Hong Kong and Singapore. And there is a growing demand in the Middle East as well. And therefore, ICC opened its latest case management office in Abu Dhabi also last year. There are also 2 regional directors appointed in Asia, 1 for South Asia, based out of Singapore, and 1 for North Asia, based out of Shanghai. Thus, these people lead ICC's efforts to connect with businesses and governments in the region and advance ICC's strategies of Asia. Now, if I just turn to the second part of your question as to how Asia compares with other regions, and if the growth as we have seen in Asia is aligned with the growth in other parts of the world, or is more progressive as compared to the other parts of the world. Now, I might share some figures with you, and that may, these comparative figures may give the audience an idea of the growth in Asia. And I'm not going too back into history. I'm just going 3 years back. And I'll just share these figures, which will speak for themselves from 2018 to 2020. If we look at Latin America and Caribbean, 2018, there were 339 cases which were filed. 2019, 386. And 2020, there were 396 cases which were filed. If you look at the percentage of the parties, it roughly amounts to 14.9 to approximately 15% over these 3 years. There's a gradual increase, but percentage-wise, it's quite static. If you look at North Africa, 2018, 60 parties were represented in ICC out of that region. 2019, the number went slightly down to 58, and 2020, it's 46 parties which are there. Sub-Saharan Africa, if we look at it, 2018, you had 122 parties, 2019, 130 parties, and 2020, 125 parties. Even if you, let's say, compare it with, let's say, Europe, Europe in 2018 had 930 parties, which went to ICC, 2019, 943, and 2020, 1040. So you will see that most of these, there is a, most of jurisdiction, we are seeing a kind of an incremental growth. But when you compare these figures with Asia, I think Asia is unparalleled. If we look at 2018 figures, 584 were the number of parties which was represented, which went to 753 in 2019, from 584 to 753, and 2020, it's 655. So if you look what's the growth in Asia versus what's growth in other parts of the world, it's I will say, on a very high trajectory. And just kind of give you an example of 2 jurisdictions which are developing economies in this part of the world. If we compare India and China to the rest of the world, we will see that in 2018, there was 47 cases, 47 parties who were of Indian origin, which went to 147, from 47 to 147 in 2019, a 3-fold increase. And still in 2020, it's 79 parties which are from this origin. So in sheer number of terms, the representation of India went from 15th position to 2nd position in 2019. 15th to 2nd, that's a jump. If you look at China, similar encouraging figures are there. 2018, 59, went up to 105 in 2019 and 80 in 2020. And China also moved in 2019 from 11th position to 5th position. Now, if you're looking at these figures, obviously, there's a huge kind of an upsurge, which ICC is seeing as far as the cases which are nationalities from Asia region, whose cases are being administered by ICC lawyers.
Thank you, Sanjeev. Do you think this is indicative of a gradual decentralization of arbitral venues? You observe that there's growth not only in Asia, but in other parts of the world. Do you think that also reflects on where parties might choose their places or seats of arbitration?
Certainly, Lawrence. I think the trend is there. If we look at last 3 years, Singapore has been 4th to 6th. If we look at China, I think it's between the top 10 of the jurisdictions wherein the arbitrations are getting seated. So I think as 2 things are happening. One is that as far as these institutions and these new venues are coming, these institutions and these venues have, I think, over time built a kind of a credibility of being professional, neutral organizations which deliver you global kind of services as far as the arbitration space is concerned. I think that's one reason, as a result of which people are quite comfortable in this decentralization. And obviously, when you're looking at decentralization, it's the entire ecosystem you are looking at. You are looking at the availability of the legal talent. You are looking at the interference level of the local courts. You are looking at expeditious enforcement of the awards when you are looking at a jurisdiction and when you are looking at a center. I think that kind of a confidence has gone up in these jurisdictions, which have time and again proved themselves to be very arbitration friendly. That's one. Second is also we see that the bargaining parity of the parties in Asia is now going up. Obviously, when you are maybe 15 years back, the bargaining parity was very highly skewed in favor of, let's say, parties in the West. But now I think the bargaining parity is also something which is equal or sometimes maybe, and that bargaining parity leads you to kind of negotiate an arbitral institution and an arbitral seat of your choice. And if obviously you have got arbitral institutions and arbitral seats, which are inspiring confidence of the global community, then those are something which are getting easily picked up. There is, let's say, agreeing to a seat other than a London or a Geneva or a Paris, maybe 20 years back, would have been very, very difficult. But now, because a Singapore, a Hong Kong, these are venues which have kind of established themselves quite robustly. I think those kind of choices are also coming in. So it's a kind of an entire change, as Julian pointed out in his brief recital of the history as to what happened in Asia, which has moved towards this decentralization. And that you are very true, Lawrence, that's not really an aspect which is merely true to Asia. That's an aspect which is gaining acceptance in other parts of the world also.
Great. I'd like to offer Kevin and then Nils the opportunity to comment on this area before I turn to Julian on the question of decentralization of arbitral venues. Kevin, what do SIAC figures say?
Thank you, Lawrence, and thank you to Maxwell Chambers for hosting this. I'm very happy to be part of the conversation, and certainly during the COVID-19 pandemic, SIAC arbitrations have benefited greatly from the physical hearings, hybrid and virtual hearings, so everything has proceeded smoothly. From an SIAC standpoint, we're an interesting case study because we started off as a regional institution and then very quickly became a global institution. And there are some compelling figures. I think there's quantitative examples and also qualitative. So by way of example, in 2020, SIAC received more than 500 American parties. And I see the same experience as Hong Kong. And it goes to the maxim of really following the trade. Arbitration is the grease on the wheels of international commerce. And if you see the east-west flows of trade, eventually there are going to be disputes. And what has been very compelling for the Asian institutions, and perhaps aided by virtual proceedings, is more and more parties are choosing to resolve their disputes in Asia. So instead of going to Paris, London, Geneva, all of which are great places of arbitration, they're now choosing to have those arbitrations in Asia. It also goes to that midnight clause negotiation that we all know about. If you have, say, an American party and a Chinese party, and they're coming with that mutually agreeable institution, it is going to come up more and more as Singapore and Hong Kong. It may well be that the American side will pitch an institution based in the United States. The Chinese party might pitch one of the Chinese institutions, but the agreeable second choice, Singapore and Hong Kong, are coming up more and more. So when we look at our users, in addition to this really big influx of American parties, we're also seeing parties from continental Europe. The overall, I guess, tone of our caseload is that almost all of our cases are international. We have cases from all 6 continents. We've had more than 100 parties in the last 5 years. And more than half of these cases have no connection to Singapore, and lots of them don't have a nexus to Asia at all. And that's how an institution really establishes itself as a global institution, is that parties are choosing the institution because that is the best way to resolve their dispute. So it could be an American party and a Norwegian party, and they're choosing SIAC as the institution. They might choose Paris as the seat because the seat is delocalized under the SIAC rules. And now with virtual hearings, they're likely going to have a virtual hearing. So I think that is helping really internationalize and globalize the institutions based in Asia that were already global even before the COVID-19 pandemic.
Thanks. Nils?
Thank you, Lawrence, and thanks to Maxwell Chambers for me as well for hosting this. It's a great pleasure to participate on behalf of the HKIAC, and I will be very brief on this point because a lot of things have already been said, and I agree with Kevin and Sanjeev on their observations. And I think we see the same thing at the HKIAC, and is driven by 2 combining factors, and it's really what Sanjeev was pointing to, with bargaining power increasing on behalf of Asian parties, combined with a very great acceptance and ease of agreeing among Western parties on a seat in Asia nowadays. In addition to that, we have, of course, the growing number of intra-Asian cases between parties from the region. With the size of the economies in Asia, there are a lot of cases that are between Asian parties, and there were some point in time where you could see 2 Asian parties arbitrating in London, for instance, but I think that is very rare today. So we have this combination of factors, and we had at the HKIAC, we also had a record year in 2020 with 318 new arbitrations filed at a combined value of $8.8 billion with parties from 45 jurisdictions. And we also, similar to SIAC, we have among Chinese parties is the biggest single user of HKIAC, and US parties are featuring very high on numbers 4. And what we also have, which we are very pleased to see, always in the top 10 parties from Singapore, and I can imagine that it is partly because that companies contracting with Singaporean companies do not want to give Singapore home turf advantage. So we get a lot of those Singapore cases, which we are grateful for. And I think with that, I'll let you go over to your next question, Lawrence.
Yes. But before we do, Julian, you've heard the figures coming out from the institutions. I'm going to suggest to you that the logical progression as countries come into their own, as they increase, there's an increase in their GDP, perhaps greater democracy, greater rule of law. The logical progression is that perhaps one day we will see Rio de Janeiro, Dubai, or Morocco and Lagos being significant places of arbitration. What do you think?
Well, yes, I think that may well be the case. I guess be interested to hear from Sanjeev on this particular point. The one thing that the ICC does, as is the only one institution, they will have an arbitration anywhere under the ICC rules. So, as Sanjeev indicated, it could be in Asia, it could be in Africa, it could be in Europe, and they've got experience. So they know some of the pitfalls and they know some of the things that are easy, only because they've been doing the cases. I think that it's very possible. I remember when I think I was a member of the court at the time, when the ICC, for the first time, sent out a representative to be the ICC's person in Asia, who was based in Hong Kong. And everybody thought, what are the ICC going out there for? So I think the institutions, we must never forget, the institutions are service providers. And if you get their confidence that that institution is able to provide the service, it's not us, it's the corporates, if they're satisfied that the institutions can provide a satisfactory system and that the law behind it will stand behind the arbitration system, enhance the system, enforce the system. Because we should never also forget, certainly in commercial arbitration, there is one thing which is fundamental: party autonomy. The parties chose to go to arbitration under this system and in that country. That's their choice. And then the institution will do what they've got to do. And if it's an ad hoc, the ad hocs will do what they've got to do. And they're not going to exercise that autonomy if they're confident that the country's legal system will substantiate it. But in principle, there's no reason. Because already I know an institution in Nigeria, they do have some cases there. I think there are some in, I don't have experience of Rio de Janeiro. And of course, Dubai's have had their number of cases in recent years.
I turn now to Nils. Hong Kong has long been a major place of international arbitration. Some would argue perhaps longer than Singapore. And despite everything we've seen in the political news that has emerged, Hong Kong is again in the survey as one of the 5 most preferred places of arbitration in the world. To what extent do you think that Hong Kong's position as a place of international arbitration today is supported by Chinese businesses proposing and counterparties accepting Hong Kong? You mentioned a little bit of that earlier in this conversation. Perhaps you could expand on it.
Thanks, Lawrence. I'm happy to. And I'll make five brief points on this question. And I mean, the first one is that we are obviously very pleased to see Hong Kong at the top 3 and the HKIAC as well at the top 3 among the preferred institutions. And we are pleased, but not surprised, given the fundamentals of arbitration that has been built up in Hong Kong over more than 30 years of experience in conducting international arbitrations, and a very solid court system backing up the arbitration system, a very favorable arbitration law that is continuously being adapted to best practices. So all the fundamentals are there, and no doubt, and this is my second point, Chinese parties and or disputes arising out of transactions with the China nexus form a very important part of Hong Kong as an arbitration seat and the arbitration market in Hong Kong. And there are good reasons for that. It's Hong Kong has unique expertise among arbitrators, among practitioners, among arbitration institutions when it comes to managing arbitrations involving Chinese parties or disputes with the Chinese nexus, and parties, Chinese and non-Chinese alike, have trust in Hong Kong as a seat for China-related disputes. But I think what is important as well, and this is my third point, it is not always, and certainly not exclusively driven by the Chinese parties. Sometimes you will find in the negotiations of arbitration clauses that the Chinese party will take a fairly agnostic approach to the seat, and as long as it is one that they are familiar with, they will be fine to settle with Hong Kong or Singapore or even a seat in Europe or elsewhere. It's equally often, I would say, the choice of Hong Kong for China-related transaction is equally often driven by the non-Chinese party. And you will see that many of the banks and financial institutions, private equity houses, and multinationals have in their dispute resolution policies and template contracts Hong Kong seat and HKIAC rules for all their China-related deals. So I think there is it takes two to tango, and it's on some occasion it's driven by the Chinese side, on other occasions it's driven by the non-Chinese side, and that leads me to my fourth point. We have seen during recent times, the last year or so, both at the HKIAC and myself in my practice as a practicing lawyer, a big drive among US technology companies to put HKIAC clauses with Hong Kong seat into their license agreements and other contracts with a China nexus, for one important reason, namely the interim measures arrangement that was put into place between Hong Kong and mainland China last year. And this has really brought a very, it's really a game changer in a way, in the sense that before that, you could not get the support of the mainland Chinese courts for interim measures for Hong Kong seated arbitrations. Now, with this arrangement, you can get interim measures from the courts on mainland China if you have the seat in Hong Kong. If you have the seat anywhere else in the world, you cannot get this support from the mainland courts. And this is very important for in certain industries, the technology sector, not the least in IP disputes, because unless you can get that support on the ground from the courts in China, there might be nothing to arbitrate at the end of the day. And we have seen a large number of companies, therefore, putting in HKIAC and Hong Kong seat in their contracts in recent years. And this is a development that sort of is driven not by the Chinese side, but by the non-Chinese side. And we have seen it in particular in the among US technology companies, as I said. And last point is that although China is very important, we should also not lose sight of the fact that there are a large number of cases in Hong Kong at the HKIAC and the other institutions that do not have a Chinese party or a China nexus to the transaction. We have disputes between Korean parties and Philippine parties and all sorts of combinations that do not have that China nexus, and it's easy to always focus on the China side of things, and China is indeed very important, but we should also not lose sight of the other important jurisdictions for Hong Kong and the HKIAC.
Thank you. Sanjeev, would you like to comment on this area on which I've asked Nils? What does the ICC perspective comprise of when it comes to Hong Kong, whether it is in terms of Chinese parties or Hong Kong being an important place of arbitration in North Asia?
So Hong Kong is an important place for arbitration in Asia. It's ranked number 10 in the 10 frequently selected cities as far as arbitration is concerned. for the purposes of ICC arbitrations. And obviously, the reasons can be many, and obviously there is a nexus with the Chinese parties. More importantly now, that the interim order, in case somebody sees that those are very critical and crucial when once the arbitration goes through, then Hong Kong becomes a kind of a natural and unparalleled choice, because that's an option which is not available to the arbitrating party elsewhere in the world. And also, as Nils pointed out, a reputation which has been built over the year of running complex arbitrations in a sophisticated manner. But all this goes, Lawrence, to the point of decentralization. The point which is there is that now people have got options, and those are the options which they are exercising. And you pointed out 3 cities, and I'll just tell you, as per the ranking of the 10 most frequently selected cities, Dubai is at 7th place, Doha is at 8th place, and Sao Paulo is at 9th place, as far as arbitration figures are concerned for ICC. And together they will constitute more than 9% of the cases where the seat has been selected. So I think people have always been wanting and are willing to exercise as long as reasonable choices are being made available to them of arbitral institutions and seats which are able to get a reputation that they are arbitration friendly and that awards would be enforced in a time. And there are quite a lot of practical considerations for the parties to choose those venues and not be just confined to 4 or 5 cities. So all this is I think, showing decentralization of power and for the purposes of, I would say, choosing the seat. And I think people are getting those options and people are exercising those options.
Thanks. And Kevin, what about India's traditional role supplying SIAC with cases relative to what the SIAC receives nowadays from Chinese parties and Hong Kong parties? Would you care to comment on that?
Yeah, sure. I mean, we continue to get a vast number of cases from Indian parties, and this is also part of the slow shift from ad hoc arbitration to institutional arbitration. In India, ad hoc arbitration has typically been quite popular, but you are seeing more and more Indian parties, not just at SIAC, but generally choosing institutional arbitration, and they're starting to recognize the advantage of institutional arbitration. If you look at India's largest trading partners, those countries also tend to be among SIAC's top 10 users. So certainly the growth of India as an arbitration jurisdiction has went hand in hand with the growth of SIAC. If I could just comment quickly on Chinese parties, I think in addition, for Hong Kong, in addition to the arrangement on interim measures, we should remember that Hong Kong and Singapore are 2 of the very few jurisdictions that have provided for the enforceability of emergency arbitrator orders and awards for both arbitrations seated in Hong Kong and Singapore, and also for foreign seated arbitrations. These can be enforceable as though they are an order of the High Court, and that has been a big advantage for both of these seats. For SIAC's part, in terms of Chinese parties, we have 2 Chinese qualified legal counsel. We run Chinese language arbitrations, bilingual arbitrations. And when you look at it across the globe with the Belt and Road Initiative, we're starting to see lots of cases where you might have Chinese investment into Africa or into Latin America. And then the dispute resolution choice is SIAC and a Singapore seat.
Thanks, Kevin. Now, Julian, did you want to comment on this area where we explored Hong Kong, China, and perhaps even what Sanjeev talked about as the new seats that seem to be emerging?
I don't know, 2 points. And I think it comes out of what all Sanjeev and Nils and Kevin have said, which is this. It's all a question of the parties being confident that the institution, if there is an institution, and the law of the place will give them the support that they need. And I think that's a key issue. It's true where Nils said, Hong Kong has been going a long time. It used to be a major center for shipping arbitration and for certain things like commodities It was almost like an annex from London. And, they followed on that. But the other thing that those, particularly what Kevin said, what's been done in Hong Kong and in Singapore is trying to keep the law ahead of the game. When they see something's happening, they're looking to adapt the law for that. You see that with respect to third-party funding. It's a controversial issue, but we know it's out there and it is happening. And rather than wait for something to go wrong, both legislatures have come up with legislation to deal with third-party funding. Whether one likes it or not is another issue, but they are conscious of the need for regulation. And I think that's a very important factor for any sector.
Let me turn now to Kevin and ask him about Singapore and Hong Kong having made their mark in the recent QMUL survey by taking 2 of the top 5 places in the world for international arbitration. Kevin, is that more a sign of the number of arbitrations filed in Singapore and Hong Kong and less a sign of the aggregate value of disputes heard in those 2 places? What if one was to suggest that the big ticket arbitrations are still being arbitrated in the West? Kevin?
I'm going to start with some statistics, but I'm not going to use the famous quote about statistics. So if you look at SIAC, HKIAC, and KCAB, if you add the caseload from these 3 institutions, it's actually bigger than ICC and LCIA put together. So the cases are certainly there, but it's a question of how do we count cases and how do we value cases? Should we put more stock in a $5 billion USD dispute rather than a $50,000 dispute? I'm not so sure. From an SIAC standpoint, we are in the business of resolving disputes. If a case is filed and the parties settle shortly thereafter, and it's good for the parties, that is the successful conclusion of the arbitration. So when you're looking at the statistics for any institution, you have to try to make an apples for apples comparison and see how they're counting. And then we're probably going to have to add in other statistics. So in addition to the case filing, what's the overall sum and dispute? How many tribunals have been constituted? How many awards have been rendered? And look at that all together. From an SIAC standpoint and HKIAC as well, if you look at the aggregate sum and dispute from these 2 institutions in 2020, 16 billion USD. Those are big ticket arbitrations that are being heard at SIAC and HKIAC. And in addition to the cases that we receive, I think it's the overall penetration of the arbitration clauses. You want to know that big entities are choosing to put their trust in SIAC, HKIAC, ICC, as the case may be. It doesn't necessarily matter if it ends up coming to a dispute. From Singapore's standpoint, with the Singapore Convention and SIAC having an ARB-Med-ARB protocol, we're also looking more at tiered dispute resolution mechanisms, mediation, a way of resolving disputes amicably. I wanted to circle back a bit and just give some of my observations on why, if we accept the premise that now these Asian institutions, that we are getting these high value disputes and lots of disputes, why is this happening? And the panel has canvassed a lot of these points. So surely it's the rise of the Asian economies and the increased bargaining power of Asian users. To a certain degree, we're also seeing new users and new kinds of disputes. SIAC has started to receive more cases involving fintech, cryptocurrency, renewables. These are new sectors that may not have previously been using arbitration. I think that it is less a case of users changing their institutional preference. If you imagine yourself in the position of a GC, you need to have very compelling reasons. If you've had 30 years of success with one institution to all of a sudden decide that you're going to change to a different institution. I do think as well, and additionally, that there is more of an acceptance of both institutional arbitration over ad hoc arbitration and international arbitration as the preferred mechanism for resolving cross-border disputes. In the cross-border context, almost every time, the choice is going to be international arbitration. And now we have all of these great options in Asia. We've also discussed the accessibility in the virtual space. For a long time, you could always choose to have your venue anywhere, but now that we have virtual or remote hearings, it makes it much easier for faraway parties to choose Asia. We also see a bit of a west-east shift. Every day, if there's an online announcement that a new highly regarded practitioner or independent arbitrator is relocating to Singapore, that shows the amount of work that is available in Singapore. And Singapore is actually an interesting example because we have a very good balance of elite local firms and then also international firms that are all sharing this arbitration pie that goes well beyond SIAC, because we have 6 major institutions all administering cases out of Singapore. And then maybe my final point on this change and how Asia is changing international arbitration really is the Asian efficiency. Professor Lew was commenting earlier in his address about these fundamental tenets of arbitration. Arbitration at SIAC just works. We are benefited greatly by having one of the most pro-arbitration destinations for arbitration, very pro-arbitration courts. We also have the Singapore International Commercial Court, the modern legislation. But the idea that you're able to get a decision quickly, you might choose the SIAC expedited procedure, that it's going to be cost effective, that you can choose your decider, limited avenues of appeal, confidential, enforceable. These are the reasons why users are choosing international arbitration and everything that we're doing at SIAC. And I think that's the reputation that the Asian institutions have, is you can resolve your dispute in a way that really adheres to why people are choosing arbitration to begin with.
Thank you, Kevin. In the interest of time, I'm going to ask Nils and then Sanjeev for their quick comments on the number of case filings versus value of disputes issue. Nils?
Thanks, Lawrence. And first of all, I very much agree with Kevin that it's always interesting with the big ticket cases, but from an institutional perspective, it's equally important to serve the large cases and the small cases, because the users are our customers, and therefore we at the HKIAC are always striving at reducing time and cost for the smaller cases, and through the expedited procedures and other measures that we have put in place. And it's very important not to lose track of that. But when you look at the caseload at the HKIAC and the value, although we do have a big bucket of smaller cases, there is also a significant number of cases that I think would qualify as big ticket cases being arbitrated in Hong Kong, and that has been, that category of cases has been growing over the years as well. And I think it has to do with something that Julian touched upon as well. Because if you look back maybe 30 years ago, a lot of the cases in Hong Kong were shipping cases, a lot of them small value. Today, a significant part of the caseload in Hong Kong is banking and finance disputes at more than 13% of the total category of cases. What we call corporate disputes, 18%, which cover disputes under shareholders agreements and a lot of the private equity related disputes that are arbitrated out of Hong Kong. And we saw last year, as an example, in 2020, we had 10 cases had a disputed amount over $200 million, 4 cases over $500 million, and 2 cases above $1 billion, and that is just cases filed during 1 year. And I have also personally in previous years been involved in a number of cases that have been multi-billion US dollar cases. So I would say that you do get both the big ticket cases to Hong Kong as well in our experience. And a last comment on that, I have never in negotiations of arbitration clauses, I have never come across any party, either a client or counterparty, saying this deal is worth too much to put the seat of arbitration in Hong Kong or Singapore. We have to have it in Europe, for instance. I have never had that conversation. So I think we will, due to the trends that we have seen, the number of big ticket cases will continue to grow as contracts mature with arbitration clauses providing for seats in the region.
Great. Sanjeev, quick comments?
Yeah, just two quick comments. One is, if we are looking at the figures today, Lawrence, there's always a lag. There's a lag when the agreement is entered into and when it goes into dispute. And that can be, you can't put any kind of a figure on that. But in my experience, I have seen that it's generally 3 years to 7 years is that kind of a lag in, if you average it out. And different practitioners would have different kind of time scales and time limits, etc. So we are looking at the figures today. Actually, we are looking at the figures which maybe were contracts which has been entered into historically, etc. Therefore, the number of arbitrations and number of the volume of the disputes which we are entering into today might not be a correct reflection as to what is going into the arbitration clauses of the parties as on date. So that's one kind of comment. But what we see historically is that Asian seats are getting prominence. And I will agree with Nils when he says that from the perspective of an arbitral tribunal, a dispute can be large or small. But from the perspective of a party which is negotiating a clause, they really don't know when the matter will the matter go into dispute, when that is going to go into dispute, and if in case it goes into the dispute, what might be the volume. You can have a tentative kind of an idea, but till the point of time the dispute really doesn't fructify, you really don't have the complete clarity on what the amount of dispute should be. But I think there should be a conscious effort which should be made because for small value disputes also, arbitral institutions should not merely only be targeting at the large value commercial disputes. I think they are in the business of providing efficient dispute resolution services, and that should be irrespective of what the value and amount in dispute is. And I think that's something which is quite close to ICC, and ICC has got a slightly different kind of a process and a procedure, expedited process in disputes which are less than 3 million. And it forms a large disputes form a good chunk of the work which ICC does. But in 2020, 422 cases which were registered with ICC were between a value of 1 to 5 million USD. So I think for an arbitral institution, it has to be kind of cognizant of the needs of the parties, and it has to tailor its kind of rules. And every dispute in case is required to be looked at differently. And if there can be why should a small dispute go through the entire process and procedure and complications which might be appropriate for a large complex dispute? So if you can have an expedited procedure which one can opt in automatically up to 3 million kind of disputes, etc. I think all the institutions should look and cater to all kind of disputes.
Thank you. Julian, I'd like to turn back to you and what you said earlier in our conversation about diversity. There is, of course, today much emphasis on diversity in all its forms, and the QMUL survey observes that survey respondents feel that although there's been some progress in gender diversity, not much has happened elsewhere. Do you feel that diversity should be an end in itself that requires no further justification? And if so, should the parties to a dispute pay, one way or another, for the road to greater diversity?
Well, it depends again who's responsible for diversity. I think one major change that I've seen, particularly in recent years, but even earlier, is at the university, seeing the number of students coming through. There are more and more people, certainly of the male and female. We've seen a complete rebalance of the students who are doing postgraduate work. That's the first thing. The second thing is where our students have come from. Now, we started in teaching international arbitration at Queen Mary 36 years ago. There are wonderful places where the subject has been taken on, from Paris and Stockholm, other places in London as well, the United States, Singapore has got Hong Kong. So it's been taught all over. And we're good. So therefore, you've now got people coming from all these regions First of all, they're studying whether they're going to join an institution is another issue. Whether they're going to join a law firm, whether they're going to government service, but they're going in with a skill and an understanding of arbitration far more than they had in years gone by. So I think that kind of diversity is happening naturally. I think there is a political element, and my role as a lawyer is not to get involved in politics. There is a political element of a lot of people who feel there isn't adequate diversity of all kinds, and there are people who feel that the institutions in particular should be doing more. I think the institutions are doing what they can do. But here's one question I don't know the answer to this. We look at a lot of arbitrations which come from certain parts of the world, and yet they will still go to the Western world, to particular, to France, to Germany, to England, Sweden, and they will look for some well-known arbitrator, even though they're maybe from Asia or from Africa, because they feel it's better for them to have this well-known person on the tribunal rather than somebody who's equally capable, equally clever, but maybe doesn't have the same outgoing reputation as the other person. So in a way, it's up to the parties to have the confidence in their own people from other parts of the world and be prepared to support them and nominate them for arbitrators.
Let's hear from the institutions. First, Nils, then Kevin, then Sanjeev. Of course, the major arbitral institutions are doing their very best on diversity in terms of appointment of tribunal members and elsewhere. But what can we really do to stop the kind of thinking on the part of parties that they should appoint a big name rather than someone who's equally talented, as Julian says, but less well known? Is there a safety factor that we can overcome in terms of party appointments or indeed institutional appointments? Nils?
I think when it comes to party appointments, it's, the institutions can play their role in emphasizing the importance of not just looking at the same names, but at the end of the day, I think that responsibility is more on counsel representing the parties. And I think at least with parties, the parties themselves that have been involved in, at least if they have been involved in arbitrations in the past, and they have seen that, always using the big wigs, so to speak, can mean that you have a much longer process due to availability. And for a lot of parties, when you explain to them the importance of a right fit for a particular case and the importance of time, that is something that parties are willing to listen to. And I think that will improve diversity among parties. For the institutions, it's of course easier because it's in our control. And for the HKIAC, we don't make all the appointments, obviously, even of the presiding arbitrators, because under the rules, the default rule is that the co-arbitrators are designating the presiding arbitrator. But we have seen very encouraging figures in that regard. And in 2020, actually, the designations made by co-arbitrators of female arbitrators was 33.3%. It is not yet 50 or above, but I think that is a very encouraging figure that shows that the co-arbitrators, when they designate presiding arbitrator, are really looking at this. And the figures for the HKIAC's appointments where HKIAC is appointing is in that same region as well. So we are doing, I'm not saying that we can't do more, but we are actively working on it.
Kevin, something to be said for gender, for diversity, other than in terms of gender, ethnic, cultural expertise?
Yeah, absolutely. Institutions are looking at, or arbitrators with both visible and non-visible diverse characteristics, the intersectionality of those characteristics. And let's think about the reason why institutions are doing it, because we want for there to be the availability of opportunity to make a bigger tent so that everyone can participate in arbitration. And we have found that diverse or tribunals with diverse characteristics make for better arbitrations. And what we're trying to get to is that we want the diversity of our arbitrators to match the diversity of our users. That's why we're doing it, because it makes for better arbitrations. Now, the institutions are doing very well. HKIAC, ICC, SIAC, LCIA in particular, with gender diversity and first-time appointees. The question is, if the institutions are doing well, how do we get parties to catch up on the nominations? What institutions have to do, in addition to appointing arbitrator or first-time arbitrators, arbitrators with diverse characteristics, is also include them in their training, public events, so that the rest of the world can see how good these arbitrators are. Or say in something, when the parties agree to have a list procedure or a strike and rank, then the institution can put forward a list that might be comprised entirely of arbitrators with diverse characteristics. Nils, I'm not sure for you, but for SIAC, when we're doing a multi-party appointment, effectively a DUTCO appointment, that's also a very good opportunity for the institution when they appoint all three arbitrators, so that you have all three arbitrators with diverse characteristics. So that's something that the institutions are doing very well on, but arbitration is a practice. We need to figure out how the parties can catch up a bit on what the institutions are doing.
And finally, Sanjeev, the ICC, of course, has been doing its very best in terms of gender diversity, and assuming that diversity, that approach to diversity relates to other forms of diversity as well. Do you think that what's happening in Asia and what's happening in international arbitrations based in Asia will change the approach to tribunal appointments internationally?
See, if Asia is becoming a bigger player, and obviously people are going to get engaged in process in which the arbitration is being going to get run, and if people find that that's an efficient way of arbitrating, then maybe there would be a ripple effect which is going to change as to how the arbitrations happen in other parts of the world. And being an Indian practitioner, I will just take three examples which I think may find way into how arbitration gets done in other parts of the world, in case people really get exposed to what's happening in India. I think first and foremost is that though there had been a lot of criticism, but it has been worked out well, that Indian arbitrations are required, domestic arbitrations are required to be finished in a time-bound manner. And most of the arbitrations are finishing in time-bound manner. And there are ways in which, in case you're wanting for an extension, etc., that extension can happen. So if people can be efficient, then obviously that's, and if there can be timelines which can be fixed in, and a country like India would be able to do it in domestic space, domestic arbitration space, which is mostly ad hoc, then maybe, I'm not sure, but maybe some arbitral institution is going to look at that experience and at least debate and think that why shouldn't that arbitral institution also have some kind of time limits and timelines for our awards to come in. Obviously, it will always depend upon the complexity of the case and other issues, and there would be a discretion given. The other thing maybe is that in our statute, we have got the conflict, the orange list and the red list incorporated. So there is not too much of a discretion which has been left out. Schedule 5 and Schedule 7 of Arbitration and Conciliation Act is something which is obviously going to guide you to whether there would be discretion with the parties, or whether that would be something which would be made mandatory, looking at an experience which, let's say, we are having. And third example might be, if you look at most of the ad hoc arbitration, which is there in India, there is, and Indian arbitration can be criticized for many things, etc. But there is not too much of an emphasis on discovery. And discovery is very short as far as Indian arbitrations are concerned, as opposed to what's happening internationally, etc. And the world community can look at whether the due process is being followed, a fair chance is being given, and whether documentation discovery can be, there are lessons to be learned from ad hoc space arbitration in India, which can be incorporated in institutional rules that can happen. So I think as obviously the arbitration is going to progress, and I'm just highlighting one or two or three instances from India, obviously, Kevin, Nils, and others who are in their respective jurisdiction might be able to point out certain things which might have worked for those jurisdictions. And as a large and a diverse pool of arbitrators is going to be exposed to these kind of systems of arbitrations and going to take back these experiences back and kind of incorporate in arbitrations which are happening in other parts of the world, or if institutions are going to sit back and look at what is working in these institutions and what can be incorporated therefore, I think that is going to lead to a gradual, it's not going to be, I would say, very instant kind of a change. But a gradual change is going to come in, and there would be inputs like Asia has learned arbitrations from other parts of the world and incorporated good points from those arbitrations which form a part of the institutional rules out in Asia. I think from Asia also there might be some learnings which might go out to the world as things progress.
Thank you. We have time for a few questions from the audience. And one of the questions that I found very relevant to our event today is the question that asks whether the Chinese Belt and Road Initiative will play a role in influencing Asian-based international arbitration. Of course, the Chinese Belt and Road Initiative is set to give rise to lots of transactions, which some of which we hope a tiny amount of which will go into dispute. These disputes are likely to be arbitrated in Asia or wider Asia. Would that kind of overland route transaction or maritime silk route transaction give rise to practices or to arbitrations that at the end of the day influence the style of international arbitration in a way, some of which Sanjeev has covered? Julian, what do you think?
2 points. First, I don't know. Second, there are things that happen in certain areas of the world which we don't always factor. I think Sanjeev touched on that, but we can all learn from other systems. But one of the things that I remember many years ago, the Honorable Tang Huzi, you may remember from China, and Dr. Tang spent some time back at ICA meetings, and also he came to London on one occasion, spoke to our students at the university, and he talked about the Chinese concept of med-arb. The idea that you appoint an arbitral tribunal, and at some stage, the arbitrators take a step to the side and say, now we're mediators, can we help you? And if it helps, it helps. If it doesn't, they carry on. Now, that's something that for our Western kind of arbitration is a no-no. Are we right? Are we right? Because arbitrators and lawyers frequently have to judge issues, is this an issue to come up or not? Now, if China is that powerful, it gets involved in transactions, maybe this is an area that will come, that they will find that at the end of the day, when you've got your big ticket arbitration you were talking about earlier, very big ticket, lots of money, lots of legal fees, lots of time, it may be better for everybody involved to actually find a way to let the arbitrator, if the arbitrators can see the way through the mess, help the parties to settle, rather than send them off to another person to do the mediation. I don't know, but that seems to me about the one kind of situation that maybe that would come out.
Thanks, Julian. Nils, Julian has referred to perhaps the Confucianist preference for harmony. Perhaps we could hear from the Hong Kong perspective whether the BRI would influence Asian-based arbitration.
I think it probably will one way or another. I mean, we are already seeing the disputes coming out of the Belt and Road Initiative, and at this stage of the Belt and Road, it's very much focused on building the infrastructure. So at this stage, we are seeing the construction disputes, and if there is one area where of arbitration where maybe arbitrations have been conducted in a way that does not save time and cost, it is large scale infrastructure and construction disputes, and there's a lot of improvement, I think, in case management techniques and that can be implemented when it comes to construction disputes to make those arbitrated more efficiently. And I'm quite sure, and we will take it upon ourselves to contribute to the development of those techniques as part of as arbitrators and as counsel in these disputes.
And of course, you referred earlier to mediation, the Singapore Convention, and all appropriate forms of dispute resolution. What do you say about the BRI and its influence?
I would second the points of Nils and Sanjeev. We're seeing these disputes coming in already, but most disputes will take 3 or 4 years before they actually reach the institution. And at what stage of the project cycle are we at? So dams may be being built right now, but are they actually being completed? Do we progress to the dispute stage? I think that all the institutions have readied themselves to be able to handle these major project disputes. If you look at HKIAC, ICC, and SIAC, fairly robust provisions on consolidation and joinder. One advantage that we've had at SIAC for these big ticket construction disputes is that our consolidation provisions don't require identity of the parties, which makes it a bit more flexible if you have disputes going across the suite of contracts, say with owner and contractor and subcontractor, and all the way down the line. So the disputes are coming in already and will continue, I suspect, to come in and have a big impact on Asian arbitration.
Sanjeev, you mentioned discovery or disclosure of documents earlier today. I'm going to ask you whether BRI disputes might give rise to less of an opportunity to obtain disclosure of documents, given that certain Asian countries are not very fond of that procedure.
So I would certainly say, Lawrence, that would be dependent upon the facts and circumstances of every case. There might be very fact-heavy arbitrations wherein maybe the other party is being secretive or not sharing everything at some stage. And therefore, in arbitrations, to give a fair opportunity, there would be a robust kind of a discovery and a documentation process that would be required. But there would be cases where completely transparent commercial transactions happening, or more going on to the interpretation of the clauses of the contract, and dependent upon the correspondence which has already been exchanged transparently between the parties. In those kind of disputes, obviously, that is something which would not be needed. But I would say that generally the way a Indian lawyer and some of the Asian lawyers would be trained would be to actually prove their case right from the hilt, have all the documentation with them, and make a case when they go to the court, and not be too much dependent upon the discovery process to make their case kind of in the proceedings or in the hearing. And if you are looking at disputes which are essentially between Asian parties, handled by lawyers who are obviously engaged in that kind of a system, then you will see the prominence of the discovery, in my view, at some stage going down, because entire objective would be to make the arbitration more efficient. And if you think that the time and the effort is not really going to worth the discovery process and what you're going to get down in that particular process, then maybe in fact cases and in certain cases that might go down. So it will essentially depend upon, obviously, there would be cases wherein this would be a requirement, but maybe a time will come that this is not going to be automatic. Discovery would be something which would be needed to be specifically asked for in a certain set kind of a situation, rather than it being kind of embedded in the procedural kind of a calendar, whether the parties need it or not really need it, or whether it's going to be effective or efficient for a case or not going to be effective or efficient for a case.
Thank you. Julian, one of the other interesting questions that's been posed is whether there is an opportunity for arbitration to promote online dispute resolution systems for smaller value disputes, because the reality is that there are many small claims out there that are not economic to bring. I recall you saying that ad hoc arbitration is not to be dismissed because it is still quite popular, but might there be a way to resolve disputes at a possibly a speedier and more efficient way than our conventional reliance on the right to a physical hearing?
Arbitration which is virtual, when you have an arbitration that is on paper, that doesn't necessarily affect parties' rights to present their case. I don't know what they're doing now, I'm not up to date, but the Chartered Institute of Arbitrators in the United Kingdom years ago had various specific programs where, for example, you could have a dispute because you went on holiday and you weren't very happy with the package that you bought. So there was a dispute that parties could bring against a travel organization. You could have a problem with your, before we had mobile phones, with your telephone provider, which is telecom. And these were facilities that were there. It was, if you like, it was an open standing. You could bring your arbitration and you put in your claim, and it would all be dealt with by the Chartered Institute would appoint an arbitrator to deal with that. And I think there are other systems around the world that would work. The point is that I think they're probably quite time consuming, wonderful for young arbitrators who've never done an arbitration. It's an opportunity to weigh up the arguments of both parties and doing everything on paper. And if you can do that, it's a great idea. Whether the big institutions would be interested in something of that sort, I'm not sure.
I'm going to ask each of the arbitral institutions whether they have plans to introduce a cost-efficient online dispute resolution system. Perhaps we could start with Sanjeev and the ICC.
So for small disputes up to 3 million, we already have an expedited procedure and a process which is faster, which is cheaper. It generally works out to be 20% cheaper, I'm told, than other arbitrations, etc. Now, obviously, as of now, we really don't have something in the pipeline, as you're asking, but being an organization which has to kind of adapt to changing requirement of the users and being utilizing all the tools which are available to efficiently discharge its obligation to kind of have a very efficient dispute resolution mechanism, you can never say no. And obviously, this would be something on which ICC would certainly be considering for appropriate kind of cases.
Thank you. Kevin?
It depends a bit on the precise construction of the ODR. There are some challenges in terms of the seat of arbitration and eventual international enforceability, but we have announced that we will be releasing the 7th edition of the SIAC rules, and we certainly want to find ways to be able to resolve these small value disputes. One way that SIAC is advantaged is that we have capped fees for both the institution and the arbitrators, so those small value disputes already can be resolved in a fairly cost-effective way.
And finally, Nils.
Yes, so I mean, similar, we have the expedited rules for small value disputes already, but we have interesting to what Julian was referring to, schemes for specific issues. I mean, HKIAC has administrated also specific schemes for small value disputes for financial products and similar that has been set up after the financial crisis, the Lehman Brothers crisis, for instance. So we have quite a bit of experience in handling that type of systems, and we are always looking at. I mean, what is very concrete is a new e-filing system that will be in place, and the step from that to go completely online for certain cases is not that big. So it's something we are considering. We are not there yet, but it's definitely on the agenda.
Thank you. Ladies and gentlemen, I'm afraid that's all the time that we have for this event today. I hope you've enjoyed this second Maxwell Conversation. If you have comments and suggestions on this or any other Maxwell Conversation, feel free to share them with us. Would you, for example, like us to go deeper into this topic of Asia and international arbitration? We'd be very pleased to consider your feedback. Watch out for our next Maxwell Conversation, where we explore good faith in international arbitration. In the meantime, Maxwell Chambers and I would like to thank our guests, Julian Lew, Sanjeev Kapoor, Nils, Eliasson, and Kevin Nash.